John L. Powell and Lindsay Grant, partners of Grant & Powell law firm, have both denied any wrongdoing as it relates to the court matter involving the firm and Tanzania Tanzil, a client who has alleged misappropriation of funds. In an interview on Freedom Radio Thursday, both Mr. Grant, a government minister, and Mr. Powell both denied any wrongdoing and said the default judgment handed down in October last year did not implicate them in any misappropriation of funds to their client. Mr. Grant explains.
Neither Lindsay Grant nor Jonelle Powell owes the claimant, who is Tanzil, or any other person any $460,000.
Or any amount.
Or any amount. I want to say, first of all, that Tanzil, and I'm going to give the facts, very brief facts, and very simplistic facts, so we could understand. Tanzil sent to the law firm of Grant & Powell some $485,000 US. He sent that matter to do three things. One, to acquire his citizenship, because he's an economic citizen. Secondly, to purchase a condominium at the Royal St. Kitts Hotel. Yeah? And thirdly, to get his passport as a consequence of all that. That's what he did. We paid out, and this is very important, Junie, because I just told you he paid us $485,000, yes? We paid out on his behalf a total of $525,000, 500. And if you do the maths, we paid out over an amount of $45,000 on his behalf. And so in simple layman terms, he owes us $45,000. That will come out in court, and that's why I don't want to complicate the matter. Those were his instructions to us to acquire his citizenship. We got that. His instruction was to get a condominium at Royal St. Kitts Hotel. He is in possession of that. His instruction was to get him his passport. He is also in possession of that.
Mr. Grant said he believes this matter is being pushed as a political ploy by the legal team of Mr. Tanzil.
A political ploy by Mr. Tanzil legal team to sully our good names in this political season.
Well, it's the
and why I said that?
well.
And why I said that? Because when we go to the order, well, the judgment of the court, the judgment of the court dated the October 28th, I think it is,
Right.
in paragraph 27, it says, it was clear that the court was satisfied that the claimant was not entitled to the order requiring them to return to him the sum of $460,000.
Right.
And why?
What time is this? From the...
This is the very same judgment, the same judgment that you've just raised.
And why is Ventus saying that? Ventus is saying that because Ventus well knows that the $460,000
was never missing.
Was never missing. It's in the condo. The $460,000 was taken up and paid over for the condo, which he has.
And
so that is why Ventus says it here, and I'll read it again. Ventus at paragraph 27. It was clear that the court was satisfied that the claimant was not entitled to the order requiring the return to him of the sum of $460,000. Can't be clearer than that.
Mr. Powell concurred with Mr. Grant that the judgment does not implicate them of misappropriation of their client's funds.
Paragraph 37. For the reasons explained above, I make the following orders. 1. The application to set aside the default judgment is hereby refused. 2. The claimant shall file and serve witness statements, submissions, and authorities in respect of an assessment of damages within 21 days. 3. The defendants, if interested in participating in the assessment of damages, shall file and serve Form 31 within 7 days of service by the claimant. 4. Submissions shall be also emailed, and that just speaks about how to file the submissions. 5. The hearing of the assessment of damages shall take place on the 12th of December. And 6. Cost to the claimant in the sum of $750 to be paid by the defendants. Junie, those are the 6 orders of the court in this judgment. There is absolutely no way in there that it speaks to any misappropriation or any other untoward activity or behavior in relation to us. It does not attach any guilt.
Granton Powell on Wednesday lost an application to appeal due to what Mr. Powell deemed procedural irregularities. He said the correct procedure has now been followed in filing an appeal and the matter should be heard before the appeal court. Andre Huey, SKN Newsline.